Local 6 Legal Line visiting with the Honorable Austin Kennady of the Bryant Law Center, Paducah, Mayfield, and Louisville, flying solo today as we are on spring break. 1-888-208-6946. Questions about personal injury. We'll get answers to those here in the next few minutes, and then we'll have a part two if we have questions there. And I think the last time we were here and we had somebody was asking about a potential lawsuit against the makers of certain eye drops. That's not really your expertise there, is it, Austin?
Yeah, I don't handle those cases at Bryant Law Center, but we do have a mass tort department that's handled by Emily Rourke and Mark Bryant. I do know that we are looking into or investigating or even taking lawsuits on eye drops. But what I would do in this case would be to call the office, ask to speak to Emily and Mark's case manager, Kirsta, and she should be able to answer any questions you have about the eye drop lawsuit.
Next question sent in by an anonymous viewer that says, my employee was running a personal errand in our company vehicle and caused a serious accident. And keep in mind, using the company vehicle was against our written policy. Can the people that they hit sue our company for their injuries?
Usually in that situation, if you're in the course and scope of your employment, the auto insurance of the vehicle your employee was in is going to cover it up to their policy limits. And then if there's an excess judgment, say it goes to trial, then potentially the company could then be on the hook for any of the damages that are beyond what the policy limits are. However, if you have a written policy, whether that's the auto policy or an internal policy, and the employee, and it's clear as day, the employee was not doing anything for the job, for the employer, not in the course and scope of their employment, respondent superior does not apply, and they would not be able to sue the company. Now, the policy itself, the auto policy, will likely still have to pay up to the policy limits. There could be preclusions, though, in that policy, so I'd take a close look at that. For example, some policies will say that for certain employees, for example, that it'll only cover to the state minimum, which, you know, in Kentucky would be $25,000. So I'd take a careful look at the policy. I would do a thorough investigation, and you'd also obviously go ahead and put your insurance company on notice.
Next question comes from Raymond, who says, my daughter lives in St. Louis and was involved in an automobile accident there. Does she have to hire a firm in that area, or can you handle her case?
I'm actually licensed in Missouri in addition to Kentucky, and we do handle a lot of auto accident cases in the surrounding states, Illinois, Tennessee, Missouri. You can go either way. If you want to consult with a lawyer closer to your home, I certainly understand that. At the same time, it wouldn't be an issue at all for our office to handle the case for you, and if necessary, I could file suit on that case since I am licensed there. Typically in states outside of Kentucky, since Kentucky is our bread and butter at Bryant Law Center, we do usually work with outside counsel that's licensed in the state where the accident took place, or we'll be filing a lawsuit, just so that we're aware of any kind of local rules or state laws that we don't deal with every single day. But as far as just handling the claim pre-litigation, that's something we do every day, and I'd be happy to take a look at it and see if I can help you.
Part one of today's Local 6 Legal Line in the books. Part two coming up. We have more questions in the pipeline regarding personal injury, and we'll try to get to yours at 1-888-208-6946 if we have time on that. Stay tuned. Part two of Local 6 Legal Line straight ahead on Local 6 Midday.